The parties all agree that Mr. Tomlinson has demonstrated some of the requirements under Article 222. There is no dispute that Mr. Tomlinson is a CARICOM national, that the right to free movement inures for his benefit directly, and the state of Jamaica has refused to espouse the claim on his behalf, given his previous unimpeded travel to and from both states. The main point in contention is whether Mr. Tomlinson has satisfied the requirement to show an arguable case of prejudice. Mr. Tomlinson contends that the mere existence of the impugned provisions amount to prejudice. The states emphasize that they are bound by the decision of the court in Myrie against Barbados, and a homosexual does not fall within the categories of persons to whom entry can be denied under the Myrie exceptions. They also marshal state practice and policy to demonstrate that homosexuals are not treated as a prohibited class for entry. The court holds that there is an arguable case that the mere existence of the legislative provisions in question amounts to prejudice, as demonstrated by the jurisprudence of the European Court of Human Rights and the UN Human Rights Committee. It also concludes that the interests of justice require that leave be granted because the issues raised in the proceedings involve significant aspects of community law, namely the relationship between domestic law and the obligations under the treaty, which merit further examination. Mr. Tomlinson is granted special leave to commence proceedings and must file his originating application within 7 days, as prescribed by Rule 10.4, Paragraph 7 of the Caribbean Court of Justice Original Jurisdiction Rules 2006, as amended.